Tennessee is in session. God save the United States, the state of Tennessee, and this honorable court. Please be seated.
Good morning and welcome to the Court of Appeals. I know this is probably where each and every one of you wanted to be today, right? That's a joke. You can laugh. Before we get started, I want to take just a very few moments and talk about our procedure. Make sure everybody understands what we're doing today and how we're doing it. I realize we've got experienced practitioners here, but I still feel the need to do this. Each side gets 15 minutes to make its oral argument. If you're the appellant and you wish to reserve any rebuttal time, you may do that, but the proper way to do that is after you've come to the podium, introduced yourself, but before you begin your oral argument, you may request up to 5 minutes of oral argument time to be reserved for your rebuttal. Obviously, Appellee gets no rebuttal time. We have a lighting aid, or we have a light on the podium that is an aid to you in oral argument. When you begin your oral argument, a green light will go on the panel. So long as that light's green, you've got plenty of time for your oral argument. The light will turn yellow, and when it turns yellow, it means you're running out of time. And when the light turns red, it means you're out of time. And we ask that you please respect those time constraints. One very important thing that I always feel the need to, I don't know if it's warn or admonish or what the correct word is. All these arguments are being live streamed. What that means for most of you is once you say something, once you put it in your argument, it's out there for the whole world to hear. So please think about what you're saying before you say it. We have unfortunately run into some embarrassing situations in the past when people have blurted out things that perhaps they wish they hadn't in retrospect. So just be advised that we are live streaming these arguments. Need to introduce our panel before I get too carried away here. Your panel this morning is Judge Carmen McGee from Savannah, Judge Valerie Smith from Memphis, and I'm Steve Stafford from Dyersburg. Miss Angie, anything before we call the first case?
No, Your Honor.
You may call the first case, please.
Taylor Thornton III et al. Versus T.M.D. Farms Incorporated.
Morning, judges.
Good morning.
Matt West, Madison County Bar. I have another attorney from our office, Morgan Weeks, also with the Madison County Bar here this morning. Thank you for your time. I would like to reserve 5 minutes.
5 minutes.
Thank you.
All right, you may proceed.
Judges, as y'all know from looking at the record, this is a boundary line dispute. The facts in this case are that there are 2 adjoining tracts located in Haywood County that share a common border, and at that border there's approximately 11 acres that are in dispute in this case. The litigation arose when the appellee created a new survey, had that survey recorded, and then used that recorded deed to attempt to have the property tax lines redrawn. That encouraged my client to then go to court to get court direction as to this disputed area. We have cited to the court 4 specific issues, but I would avert to the court that the first one, the one as it deals with the taxes and the statutory structure with the presumptions, would pretermit all the other issues. That is the statutory construction that places the burden, the onus, on the owner of property to have property assessed properly and then to pay the taxes on that assessment. And we believe that the proof at trial, this issue of taxation, I should say, was brought up twice. It was brought up at the summary judgment level. It was also brought up at the trial level. And we believe that the proof showed that the disputed area, this disputed 11 acres, has been taxed to the appellant, my client, since at least 1967, has not been taxed to the appellee during that same period of time. Arguments have been made back and forth that there's an argument made that there's a possible overlap. The property assessor was vehement in her response that there is no overlap here. And so we take the position that by law, by these two key statutes, which is TCA 28-2-109 and 28-2-110, that by law, my clients are the owners of that disputed tract. And again, what we're asking the court to do is to keep the lines as they are. If we were to follow the logic of Appellee and the logic as espoused by the court, that will require the changing of the tax map. We're asking that it stays exactly like it is, like it has been since at least 1967. And again, the chief basis for that is these two statutes. So I'll look at TCA 28-2-109, and that is a statute that creates a presumption, a prima facie presumption, in a property owner that has paid taxes on that property for in excess of 20 years. There's a legal presumption, rebuttable presumption, but a presumption that they are the owner. And perhaps even more importantly is this 28-2-110, which has this similar language that says that if someone has been paying taxes on a property for more than 20 years, if someone has not been paying taxes on that same property for more than 20 years, they are, quote, barred from bringing any action. To me, that has been key in this case.
What do you do then with the evidence that was introduced that is contrary to your position?
Yes, Your Honor, and I'm glad you said that. That's exactly right. And remembering the standard that, and we cite the cases, the standard that follows Tidwell, Alexander versus Patrick, 656 Southwest 2nd 376, and Burris, 656 Southwest 2nd 707, that puts the onus on the property owner to do two things: have the property assessed properly and pay taxes on that property. And the only proof that I submit to the court that the court should look at is the testimony of the property assessor. The property assessor is in the best position to know who's been paying taxes on this property and for how long. And the property, yes.
In looking at these statutes, and you seem to argue that this is conclusive. You said this pretermits everything else, that if you look at these statutes, that's it. But in looking at these statutes and the argument that you're making, you seem to be advancing an argument that tax maps are the be-all and the end-all of property lines. And I don't think that's the way the law exactly reads. I mean, a tax map is a tax map, but tax maps can be lots of things, and always accurate is not necessarily one of them.
Well, Your Honor, what I would say is we look hard at that statute 28-2-110 that says if you haven't been paying the taxes on it, then you're barred. And I am saying, Your Honor, to follow what your point, that Tidwell, Alexander, Burris line of thinking, each one of those cases, by the way, had similar arguments. There was one of those cases an overlap argument. One of those cases is they said it's unclear on what we're paying taxes on, I think, which is similar to what the court's saying. And then one of the other cases says we were not billed properly. In each one of those cases, the court came back and said, wait, property owner, you have the burden of making sure your property is properly assessed and then paying taxes on that assessment. And so I do stand firmly that I believe it does permit the others. Now, those other issues are important issues. I don't want to gloss past that. But those issues, you start getting into competing surveyors. You start getting into issues of clouds on title. You start getting into issues of property color of law. If I'm accurate in that by not paying taxes on that disputed property for over 20 years, all the way back to at least 1967, that solves all those other three issues. it becomes the straightest line, the closest distance between two places is a straight line. It sews all those up.
I guess what I'm asking is, what proof do we have in the record that the tax map is conclusively correct as to the boundary lines of these individuals? Because these, as tax maps have evolved through the years, they've gotten better, but they're not, I don't think, as on the level of an exact description as far as those lines.
That may be true, Your Honor, but it demonstrates what taxes have been paid, though. It demonstrates what the property assessor's office is showing is being taxed. And to follow the actual testimony from the property assessor, she actually took the stand and provided proof at trial. She says that the appellant paid the taxes on this tract, included the disputed area, back to at least 1967, that the appellee, T.M.D., did not. And she affirmatively, when asked whether or not there's an overlap, she did not believe there's an overlap here. And so, while I agree with the court that property lines, you start wondering if the property lines themselves answer the question, in essence, this tax statute gets around all that. The tax statute is there to help provide some sort of finality on those questionable property line distinctions. It says, well, look, wherever those property lines might be found, if you're paying taxes on it for 20-plus years, you're going to get the legal presumption of ownership. And if you have not been paying taxes for 20-plus years, you're barred from bringing that claim now.
What was the evidence from the other party regarding payment of taxes?
Right, so T.M.D. would argue, well, Judge, we surveyed the property and we have been paying taxes on 73 acres. Now, they are not able to firmly say where those 73 acres are because that doesn't show up on the tax map. But they're able to say somewhere we paid 73 acres. And there's no conclusive argument from them as to that because they can't, because the property assessor doesn't show them paying that.
But what they said, as I recall, is that the only way you get 73 acres is if you include this 11 acres.
Right, but I hope the court sees what I'm saying, though. The statute permits all that. The statute says.
I see what you're saying, but what you're asking the court to do is to say that essentially any testimony from the tax assessor is the be-all, end-all, as Judge McGee said, which I got a little problem with that.
Yeah. Well, I would then ask the court to really look hard at those three cases I mentioned earlier, because those are the exact same three fact patterns in those cases.
We will look really hard.
Yeah. I also want to say real quick also, as we look at the actual ruling from the court, one of the things that the court brings up and argues is some form of express payment of taxes from my side and an implied payment of taxes from the other side. I've not found any justification for that anywhere in any kind of case law. And I certainly would ask the court to look hard at that finding of express payment versus implied payment. I've not found that anywhere in any kind of case law whatsoever. I think the property assessment map is what it is, and I'll step aside. Thank you.
Thank you.
Good morning, Your Honors.
Morning.
Dusty King with the Madison County, Tennessee Bar and the Baldwin County, Alabama Bar here on behalf of T.M.D. Farms. Without rehashing the facts that Mr. West pointed out, I do want to address the arguments, starting with the issue of whether the trial court erred under TCA 28-2109 and 28-2110 by awarding the disputed area to T.M.D. Farms. The evidence, I think, is very clear. The court's addressed this issue, as Mr. West pointed out, on two different occasions. First was on the motion for summary judgment, where the court did find there was a genuine issue of material fact regarding the payment of the property taxes. And then the second time during trial itself, this was presented. And the court properly found that T.M.D. Farms had paid the property taxes because we provided 30 years' worth of receipts showing the payment of taxes on 73 acres in Haywood County. To remind the court, the T.M.D. Farms tract is the county line between Crockett and Haywood County, divides the 100-acre tract. 73 of those acres are in Haywood County. Now, you take the tax receipts for 30 years coupled with the two surveys, one from Mr. Michael Manus and one from Mr. Bruce Richardson, which clearly showed that when you look at the tract that belongs to T.M.D. Farms, at least 73 acres are located in Haywood County. Chancellor Mansfield properly deducted that if we've been paying taxes on 73 acres and we have 73 acres located in Haywood County based on the surveys, T.M.D. Farms has been paying the taxes as been assessed. Now, today, Mr. West says that it is essentially up to T.M.D. Farms to make sure that the taxes are properly assessed and they are paying taxes on that assessment. And I would assert to the court that it's correct. We have been paying taxes on 73 acres based on the two surveys. 73 of the 100 acres of the tract are located in Haywood County. Therefore, we have been paying the taxes. The tax has been properly assessed, and T.M.D. Farms has been paying taxes on that. Mr. West referred to the testimony of Ms. Goldie Harwell. Ms. Harwell also testified that overlapping tax payments where two parties have paid taxes on the same property was common, and the tax records do not conclusively establish title. That's in the trial transcript, volume 1, page 91 through 94. So the appellant's argument fails because, one, they would have the trial court and this court ignore the fact that T.M.D. Farms and its predecessors had paid the property taxes as assessed on that 73 acres and ignore the surveys showing where the disputed acreage is located. And they would have the court hold that the tax map, as the court's already pointed out, is really the end-all, be-all, and the only evidence to substantiate who's paying taxes on what land, and that's simply not the way the case law reads. The case law reads that a tax map can be provided as evidence, but it is not conclusive evidence, and no other evidence should be concluded, and Chancellor Mansfield properly found that. And then 3, I would establish that it is the burden of proof for the appellants to show that they had paid the taxes to the exclusion of T.M.D. Farms, and that's simply not the evidence. Quite frankly, I believe that both parties have been paying taxes on this property, but that in and of itself does not save the appellants in their argument. They have to show that they have been paying taxes to the exclusion of T.M.D. Farms. And as the court here has properly pointed out, there's a lot of evidence that the appellants would just have the courts ignore in the form of the 30 years worth of tax receipts, the surveys provided by T.M.D. Farms. Chancellor Mansfield did not ignore that, and I would argue that evidence simply can't be ignored. Addressing whether the trial court erred in awarding the disputed area to T.M.D. and failing to give priority to the natural and man-made monuments as required by Tennessee case law and generally accepting survey practices. Chancellor Mansfield went into very extensive detail on how he determined which surveyors were more reliable, how he found them to be more reliable. He goes into a lot of detail there. And again, relying on the Manus and Richardson surveys, they found their point to be beginning to be a man-made monument of Johnson Grove Road. This is Technical Record Volume 2, page 219. And the trial court's finding of the location of the boundary line is entitled to a presumption of correctness as ruled in the Faust case. And as the trial court explained, it specifically found that Mr. Richardson and Mr. Manus were able to correctly establish the northwest corner of the ward tract from a deed in the defendant's chain of title that was drafted in 1896. And that from that point of beginning, the metes and bounds description of the northern, eastern, and southern boundaries of the defendant's tract matched the Richardson and Manus surveys. So the chain of title that the appellant simply claimed, the chain of title of the appellants is simply not as reliable, mainly because it goes from a bounded deed where it says it's bounded to the north by Conyers, which is our predecessors in interest, to a metes and bounds deed, and then inexplicably it jumps back to a bounded deed.
Did that description not use for reference a river as well?
I don't believe that legal description used a reference. If memory serves me, Your Honor, Mr. Jonathan Dodd, the surveyor for the appellants, found that reference to a river in a different deed when he was checking surrounding properties, and it was the surrounding properties description that had referenced the river. But his point of interest, his beginning point was, I think, in the southern canal of the Forkadere River. So that's where that reference is coming from. But it was not actually in the appellant's chain of title.
Okay, thank you.
Let me ask you a question about standards of review here. We're talking about expert proof, okay? You got, what we have, 3 experts, I think?
3 surveyors, yes, sir.
And trial court basically was very complimentary of all 3. Said they're all very credible, did what they were supposed to do. And this is where I'm going with the question. The trial court didn't say that your methodology, well, it sort of found the methodology wrong, but it essentially drilled down more than I've seen most trial courts do in the past. Trial judge did an excellent job of understanding the issues and laying out his analysis and reasoning. And I think it makes the appellate court's job much easier by the way this trial judge did his job here. But what is our standard of review when the trial court, in this instance, actually found all the expert proof credible, but found your expert more credible based upon his methodology, based upon his analysis?
Your Honor, I outline what I think would be the answer to that question in my brief. Essentially, I think the case law shows that the trial court is in the better position to evaluate the credibility of those experts. I say on appeal, considerable deference is given to the trial court's determinations and the credibility and weight to be given to witness testimony because the trial court had the opportunity to observe the witness's demeanor and hear in-court testimony. And then that is citing, that is Wood v. Starko citing Massey versus Castles. And then the deferential standard specifically applies to a boundary line dispute where the trial court must choose between 2 competing surveys. And that is also the Wood case citing the Pierce v. Pascal case. Furthermore, the weight of the theories and the resolution of legitimate but competing expert opinions and matters entrusted to the trier of fact, that is the same case referring to Brown versus Crown Equipment. Expert testimony is not conclusive, even if uncontradicted, but is rather purely advisory in character, and the trier of fact may place whatever weight it chooses on such testimony. That is, again, the Massey case citing the Thurman versus Sellers. So,
And I agree with everything you said.
okay.
But I think we've got another layer of analysis here. In this situation, opposing counsel has pointed out that here's the general rule as far as a surveyor when we're looking at a boundary line.
Mm-hmm.
The trial court went further than the general rule. The trial court said, I understand the general rule, and I'm paraphrasing here. I understand the general rule, but I think to get a more exact analysis that the way that your surveyors did the survey, what they used as their beginning point and where they started was the oldest deed they could find that referenced a particular point is the best way to do that. So my question is, what is our standard of review of the trial court's analysis of that? Because the trial court basically, I think, made some findings of fact as to the best way that an expert opinion should be offered in this particular situation. Does that alter the way we look at it at all?
I don't think so, Your Honor. I think that deferential standard still applies.
You can respond to that when you get up here.
Because, I mean, the whole purpose of giving this deferential standard is because Chancellor Mansfield in this case was in a better position because he got to hear the expert testimony, he got to study on the surveys, he got to hear the experts testify to the surveys, he got to hear and weigh the evidence. So the fact that he is taking an additional step and saying that this is the approach that I think best suits this particular set of facts. And I think these two surveyors, Manus and Richardson, took this approach, and I'm relying on this approach versus this approach, because he does state in his ruling the reasons why he felt that the Manus and Richardson surveys were more reliable than the Dodge surveys based on those approaches. I think the court should give deference to Chancellor Mansfield because he's in that position. I don't see that the fact that he took the other step changes that.
Well, I don't think I'm articulating my question very well.
Okay.
Are we looking at an abuse of discretion, or is this a factual determination?
Oh, I think this is very much a factual determination. I mean, I don't see that this is an abuse of discretion because Chancellor Mansfield painstakingly laid out why he relied on the Richardson and Manus surveys versus the Dodge surveys. And it was based on the fact of really the starting points, the chain of title for T.M.D. farms dating back to 1896 versus the oldest deed provided by the appellants being 1919, and the starting points of Johnson Grove Road versus I believe it was the South Canal of the Forked Deer River. I mean, he went into painstaking detail of the factual basis.
I agree with that. But if it's a factual dispute, what's the factual dispute that this court's supposed to determine? Because it all sort of collapses into a review of an expert opinion.
I think therein lies the standard of review that deference is given to the trial court.
Hence my question.
Yeah. Deference is given to the trial court in this situation, I believe.
I mean, what we're looking at from your perspective is not only a factual analysis, that the trial court determined the facts correctly, but also then we're looking at an abuse of discretion analysis as well.
Your Honor, respectfully, I just don't see it as an abuse of discretion. I see it as this is a factual basis that Chancellor Mansfield is trying to determine between three experts who's correct and who's not. And he's looking at the analysis that those experts went through in the process they went through to determine where these boundary lines are. I think I understand the court's question, but I just don't see it as an abuse of discretion. He took the time, made the effort, went into excruciating detail in his ruling as to why he ruled the way he ruled.
I agree with you. He did. I wish all trial judges would go through the type of analysis he did, because it's very helpful. There's no question about why he did what he did, because he explained exactly why he did what he did.
And I just don't see that as an abuse of discretion. I see that as just a very thorough evaluation of the facts and the expert opinions that were presented to him, and he made a ruling based on that. Thank you, Your Honors. I'm down to 7 seconds, so I'll wrap up. Thank you.
Thank you. Mr. West, you may provide some clarity to that discussion.
Thank you, Your Honor. As I analyze the case, I see two different standards at play. So first of all, we had a summary judgment motion. So I do think that is a de novo review. But then also, as the court mentions, if we get past the summary judgment, past the tax issues, then you do get into an issue of competing experts. That is a de novo review with a presumption of correctness, which I think is what the court is trying to say. But there is absent clear error of law is that standard. And so to me, there was clear error of law in the findings, and of course, we've outlined all those more fully in my brief. But they essentially provided, yes, 2 surveys. But the first survey was done through field work done by a party, which we believe is a biased opinion.
Court dealt with that.
And I respectfully yes, Your Honor, he did. And then the second survey, the maintenance survey, essentially tracked that same logic. And so we feel that those are clear errors of law of doing that, of selecting that versus what we feel was the superior surveyor. And then also, in terms of law, we reference this Haydad family partnership case. In Haydad, the court specifically says, you know what, no, we have standards that our surveyors have to provide, and we've given them a list of priorities. And those priorities at the top of the list are monuments, natural monuments, man-made monuments. At the bottom of the list are legal descriptions. I think the court was accurately asking questions earlier about the legal descriptions. By the way, both legal descriptions contain the disputed area. But in that list of priorities, the monuments come first. And Surveyor Dodd specifically says, he references the Forked River, he references 2 buggy axles, he references a fence line, and he references an old barbed wire fence as his justification for how he came out with those survey lines. In trial, the surveyors for the other side had to concede that they never even went to go look at the northwest corner of my client's property. They never even went over there because there was a ditch filled with water, so they couldn't get over there, but they didn't go. And if they had, they would have seen this buggy axle that was there, which is a man-made monument, which does supersede meets and bounds legal description in calls. So I think those are clear errors of the law in this case. And I think for those reasons also the court should be set aside, the court's ruling should be set aside. And then also, this was mentioned as well, and if the court has the maps, they'll be able to see it in pink. But the Surveyor Dodd says that to do what, on the survey, what the other side was doing was essentially to take their track and shift it down. And in doing so has created, and I believe it'll be highlighted in pink on that map, has created dead zones, no man's land, where there's questions of ownership of those, which I believe creates a cloud of title on multiple property owners. They're mentioned in the trial, scallions. Well, I'm not going to go into all the names. There's multiple names that are possible property owners that will have possible clouds in their title because of that shifting of that track south. And so,
Mr. West,
yes.
Let me ask you a question before you run out of time. I've heard nothing today really argued or mentioned about the court's alternative ruling.
Yes.
What in the record would support the court's alternative ruling?
I have found nothing in the record that supports the court's. The court's alternative ruling was that there was a color of title through TCA 282-105. And the problem with that ruling is to find adverse possession under that statute, you have to have color of title. And judges, my client has color of title. My client has a deeded description back to 1936, at least, that has the disputed area in their track. And so you cannot proceed under that statute unless you have color of title. And in our case, we had the color of title to that track. So I did not find evidence that I think that would have supported that alternative finding at all.
Thank you.
And again, the taxation issue, I think, pretermits all those issues as well. Thank you for your time, Your Honor.
Thank you, counsel. We appreciate your briefing, your argument. We will take this matter under advisement and attempt to get you an opinion at the earliest possible time. Thank you. You may be excused.
Thank you.